All right. Thank you, everybody, for showing up. I appreciate it. Kind of the basics. Several of you have used this room, but some of you haven't. The restrooms are right through here. If you need a break, we'll take a couple breaks as we go along. Obviously, everybody can sort of see the food and stuff. So, with that, we'll get going. If you need, if I'm not loud enough, let me know, because I can tend to be quiet. We do have a microphone. Thanks, Dean. I do have to make a disclosure. This is a bunch of individuals hanging out at a Captain office. This is not a Captain sponsored or endorsed class. They want to make sure that we're here on our own. So when you look at wealth management and you start looking at the job description, it's pretty interesting if you talk to people that do it. They've got the obvious, the financial planning, the estate planning, tax planning, charitable planning, guiding your clients to growing, protecting, and kind of the general wealth management. But what's not on the typical list is also helping somebody's child manage their money, or helping a distant relative that's having trouble, that's connected to the family with their struggles. So from what I understand, they can wear a lot of hats. So we have 3 people here today. Charlie is over here standing to the back on the right. Charlie Douglas. He's been doing this for 30 years. He's the editor of the Journal of Estate and Tax Planning. He serves on a legislative committee, and he's the senior VP of Wells Fargo. He's a wealth management consultant in Atlanta. Julie Krieger in the back. She's been doing this 27 years. Most of her career has been around wealth management. She has a master's degree in taxation, named top woman in finance by Finance and Commerce. She used to be with a company called Lowry Hill. She was the wealth manager and their CFO for a number of years. And then they got bought out, if I recall, and then she and a handful of her kind of favorite friends went to Evercore. That's where she's been since then. So, and then Mike, he's also right here in the back. He's a chartered financial analyst, so he's the guy that picks stocks and funds. So we thought it'd be fun for him to come and teach us about stocks and other types of investments. But he's integrated in the portfolio management part of the firm. So our plan today is get close to me for a few minutes, and then we're going to go to the professionals. Charlie's going to talk to us about trust, estate planning, asset protection. Those are his kind of areas of expertise. Everybody overlaps, by the way. Julie is going to do CPA, need, and wealth management. Wealth manager, choose one, what to look for. And Mike's going to teach us about how to invest. We'll have some wrap-up thoughts, and then the last chunk, because I assume there'll be a lot of questions, is I tried to leave enough time that it's for us to use as a question and answer series, almost like a panel. Get everybody up here and ask me questions. Like any good person will do, when I first realized that this was possibly going to be real as far as selling the company and getting a big check, I Googled, what do you do if you get a big check? And it was really kind of interesting because I got a little bit of everything. In this one blog, the guy said, everything from take a year vacation, go have a great time, to a very methodical, find these 3 professionals, break your money down in these parts, make sure you're diversified, very kind of methodical planning. But it was an interesting starting point, because basically I saw every answer to the sun. So with that, everybody in the room has a unique path. Everybody in the room has a unique story, things they're bringing to the party, things they're planning to do. Incidentally, we're going through a life change, theoretically, especially a number of us that are a couple years older. So what do you plan to do in the future? Are you still going to work at some capacity? Do you think you're going to do another business endeavor? Because all those things affect your decision. Am I done? Do I want to quit, or do I want to partially quit? Do I want to travel? Maybe I'm going to go to a little apartment and just spend the rest of the time traveling around. Or do I want to get that lake home that I've always wanted? Or is Dean finally going to buy a game? And who do you have to support? I've still got a 9 and 11-year-old. I've still got to get through college. I've still got to get through high school. So I've got a few years to think about them. And in my case, neither of my in-laws nor my parents planned. So I'm looking to have to support some seniors at some point as part of my planning. So each of you, again, what I want you to do is look at your story and look at what your your needs are going to be. With that, once you have that, you're going to basically make a budget or a plan. What do I need to do? How much money do I need to have per year? And it's sometimes interesting if you ask the husband or spouse, you know, I need 100,000, I need 400,000, but you have to come up with a number you're happy with. Professionals are happy to do this for you. If you have a financial advisor, that's something they easily can help you do. There's programs that can do what ifs. They have some very sophisticated ways to help you. If you do use Quicken at all, it makes it pretty easy. The Premier version has a planner built in. It's a kind of a planner for dummies, if you will. Lets you set parameters and say what ifs, and it will give you, does your plan work or not? Do you have enough to retire or not, or what can you expect for longevity? I'm sure nobody's afraid about making the wrong decision with their proceeds. But supposedly that's one of the biggest things that we'll face. The second one is kind of an interesting one because it's emotional. You know, what do I do? We were having a great conversation at dinner last night, and so we came up with a couple really good ideas. Probably not the right audience to say everything to, but it was interesting to watch us go through what do we do next. And we've been entrepreneurs our whole life, we've been veterinarians our whole life. That's kind of who we are. What's next in the path? But just be aware that that's normal. So if you sit around and go, it's normal. That's what you're supposed to do. So most of us need 3 professionals. We need either a trust or an estate attorney, somebody to help us make sure we have the right documents in place. And that's so it doesn't all go to the government at the end of the day. We need a CPA. Now, CPA, and we'll get into a little later, is you have the person that does your tax returns, and you have somebody that does strategic planning. And it can either be one or the other. Sometimes they do both. And from what I understand, it's common that all 3 people work together. But for a lot of people, the wealth manager advisor is the quarterback. They're the person that kind of puts everything together for them. But I think there's a lot of different scenarios for that. So with that, I'm going to turn it over to Charlie.
Can I
Yes, please.
interrupt for 1 second? Sorry, this is a procedural thing. Dennis asked me to try and get the signatures of everybody in the room here. If you haven't signed the original thing here, you may have signed something at
Talking about the
at
shareholders
home.
agreement.
Yeah,
Okay.
for the shareholders agreement.
So
I'm going to pass this around. If you've signed it elsewhere, sign it on this one if you don't mind. If you haven't, sign it, and then check off your name on the front page. Okay, I'll start with. Thank you. Sorry.
No worries. If I can ask, if you don't mind, I'm going to slide that over there. We're trying to video too.
Sure. So you want to go ahead and move this on over? No worries. You have to.
Also, so another thing is if you own stock as part of a trust, there may be 2 signatures, maybe 2 places to sign. One as the individual and one as the trustee. Thank you.
Does everybody have one of these? I think so. Hi. All right. Great. Good.
Should be. Mine has a really easy way to block that. All right, I think it's going down.
Yes, the
All right.
lowest power down projector there is. Hi, good afternoon. How are you? Charlie Douglas. I'm from Atlanta and work with Wells Fargo Bank. My goal for the next 45 or 50 minutes really is summed up in 4 words. Plan better than Prince. Right? In terms of the estate plan. It's a cute story, and Everett and I, we were chatting on the way over. I do some writing and speaking every then and again, and I worked with, on Friday, I work with Investment News. People, you would be in the back familiar with Investment News, Mike. And I end up working with celebrities when they die. So they call and kind of my background and where does the story go and what do you think and so forth. So I worked on that, and then over the weekend I got an idea to write an article, because have you not seen Prince overload in terms of articles, right? So I wanted to go ahead and write on Prince and the right of publicity. The concern being that he had, and everybody, if you know about Prince, was very concerned about maintaining control. Was he not during his lifetime over his artistry, his music, and his persona? Very difficult to find his stuff on YouTube, would have attorneys contact people on Facebook if they were bootlegging his material. Well, in any event, when someone dies, the right of publicity doesn't necessarily pass on to heirs. Think about that. California, Michael Jackson, statute that protects it, passes it on. Tennessee, Elvis died in Tennessee, there's a statute that protects it, passes it on. I'm from Georgia, we don't have a statute, but we have a Supreme Court case. Anybody heard of Dr. Martin Luther King? Supreme Court that said there is a inheritable right of publicity, name, likeness, and persona that protects the family. That doesn't mean that the estate can't make money, but what it means if you don't have a protected right is, say the three of us, if we wanted to open our own t-shirt company to go ahead and sell Elvis or Michael Jackson or Prince, there's nothing, if this estate doesn't have that protected right, they can't stop us from making money on our own. So it's really particularly important. So anyway, long story short, I worked really hard this weekend because I wanted, it was this little niche article angle. I got it done and did it with Trust and Estates and got it out Tuesday. So whew, got that done. And I don't know if any of y'all have written papers or something. It's kind of like a small level, maybe the male equivalent of birth or something. You know, you're just very happy, right, to get that over and it's out there and done, you know? So I get on the plane this morning. This is a big day. I get on the plane and I pull out the Wall Street Journal, page 1. Now again, my article that you have, I think I said, when heirs cry, so that's the playing the words, when doves cry, and it's only written really about the valuation and potential loss of Prince's image and likeness, because Minnesota, unlike the other states, doesn't have a statute or case law protecting that right. So he can lose that. So I pick up the Wall Street Journal, page 1, I'm on the plane, and it says, what is Prince worth? The tax man needs to know. And here's what it is. Musician's estate has to value his likeness, the Jackson dilemma. The beginning, I just read the first line in the first paragraph. After the doves cry, there's a 706 IRS form, estate attorneys and so forth need to really determine the financial likeness, image, and value. Well, that's what I wrote about. So I'm reading through this and I'm saying, in fact, I emailed the guy from the Journal, so we're going to talk later, but I just said, you know, great minds think alike or whatever, but when you do a lot of publishing, you know what's out there on the internet. You know if it's out there. And you can't protect in a way, you hope nobody lifts your material, but you can't kind of protect your ideas or whatever. So this was a big day for me because the Wall Street Journal kind of lifted stuff that I did, and that's never happened to me before. So anyway, I wanted to share that. The agenda that we'll have for, again, the next 40, 45 minutes will be looking at how much is enough. I think that's important. That drives planning, drives investing. Titling and estate planning documents, at least the essential ones. Trusts and trustees, talk about revocable, irrevocable trust. Advanced estate planning thoughts and asset protection. And then some thoughts around picking a team of professionals and collaboration. I liked how you said it's important for people to work together as a team to collaborate. And the idea is if there's things when I'm talking that come to mind, please jot them down as questions, and then when we have the panel, after both presentations, we'll go ahead and do that. This is more of a resource material. You don't have to sit and read it, but we'll go through it. I made notes and may suggest kind of making notes right here on the tab, or questions on the tab. So if we look at tab 1, if you have it, I just have a hypothetical nest egg. Anybody, you know, over the weekend when you see for sports that ING kind of dumb commercial, it's what's your number, right? Do you remember that? And you know, the guy's cutting his grass and it's like, oh my gosh, I don't know my number. Knowing your number to some degree will drive planning. It will drive investing, right? Depending upon what your number. So I wanted to give you just kind of a hypothetical that I've used. This is not a sophisticated Monte Carlo analysis, but it's a thumbnail I often use with clients that would say this: look, if my monthly cash needs are $40,000 a month, my rate of return, let's say, is 6, and the inflation rate is 3. And by the way, the difference between rate of return and inflation rate, what do we call that? The real rate of return, right? So it doesn't have to be necessarily 6 and 3. We could say we could invest to do better than that. Maybe it's 7 and 4, but I think what's important is a 3 to 4% real rate of return is reasonable, right? Is reasonable. And you know, when I started in this business 30 years ago, I don't know where 30 years went, right? Does anybody else feel that way? Where did the time go? You know, people would say, I'd say life expectancy, well, I had a mother, you know, they lived, grandfather, to like age 80. You know, now, if people reach late 50s, early 60s, there's a better than 50% chance that someone is going to live until their 90s. So you're looking probably at 4 decades of needing to keep up that rate of pace with inflation to be able to do that. So for here, if it was a 50-year-old, I needed 40 years to take me to 90, and this is spending the whole nest egg, principal and income, and again, real rate of return. What do I need to put away today to give me $40,000 a month at 6%, 3% rate of inflation? If you notice, I didn't put taxes in here. I needed $11 million, a little over that. And you can play with that. So if you look at the chart, you can look at rate of returns and you can look at inflation rate and kind of see what the different values are too. But I think that's important just to start off, that as you plan, as you look at investing, try to get a feel for what your number is. One of the limitations of this Excel schedule and model is, obviously, we don't get a consistent 6% every single year. We don't get a consistent 3% every single year. But it's a good thumbnail to say, if I just want to have an idea of what that might look like. Okay, tab number 2. Wanted to talk about titling. I'm hearing that wires are coming in, right? They're going to do little testers on a wire, you know, for, I don't know, $100 or $75 or whatever, making sure it gets in the count. Titling is so important. So I wanted to mention a little bit about that, because that can supersede an estate plan that you have. And I want to go ahead and mention that. Let's say that I have an estate plan, a will, that I say I want to go ahead and leave my estate half to my wife and the other half to my 2 children. I don't want to do that when I die. That's what I want to go ahead and do. But if I hold all of the accounts, which is very simple, the accounts to the house, real property, my investment accounts, if I hold those in joint tenancy, even though my will is very clear, that will pass in accordance with the laws of really joint tenancy, where you file an affidavit death of joint tenant, and it has to, by contract of law, it has to pass to the surviving joint tenant. So even though your will says, here's what, if you own it in joint tenancy, that will supersede it. So it's important to think about, how am I holding titles? Should I be holding it as a joint tenant? I'm going to talk later about the estate tax aspect, and there's a thing called generation skipping planning. Some of you may be in that and want to be thinking about that. If you talk to your lawyer and they've mentioned, he or she, you know, we want to preserve your ability to generation skip, which essentially means it's not going to be taxed in your children's estate. In order to fully fund that exemption, I would suggest having the assets owned as tenants in common, not joint tenancy. Why tenants in common? So each spouse, tenants in common is 50% each, and then you can go ahead and choose to leave it to whoever you want to, but that will allow you to fully fund a generation skipping exemption. And again, that'll be more to come on that. Anybody from a community property state? I practiced in California for a long time. Anybody community property? We're in one right now, right? Community property. One of the really cool things about community property, there's a rule called step up in basis. So if I have something that I bought for $500,000 but is worth $2 million when I die, you and I know that if you sold that during lifetime, the difference between $2 million and $500,000, if I've held it, would be long-term capital gains. it's community property, either my wife or myself dies, there's a full step up in the cost basis such that the survivor can turn around and sell that asset and pay zero capital gains. If I have real estate and it depreciated all the way down, one spouse dies and there's a full step up and you can re-depreciate the property. So the difference between community property is one spouse dies, there's a full step up. In states like Georgia, separate property state, if I die with the asset in my name, there's a step up in the value, but there's not a full step up or not any step up if my wife dies and she's not untitled, right? So community property is kind of unique, but that would allow you also to fund, if you will, use your allocation for a generation skipping exemption. And then, does anybody have, we're thinking about revocable trust, right? Revocable trust, anybody have that? When I practiced in California, I did hundreds and hundreds of revocable living trusts. I'm gonna talk about that in a moment, but the key thing is if you have a revocable trust, I don't know, somebody was in here saying you have to sign in 2 places, right? You know, all of that. The key thing, and I'll talk about it again, is to make sure you take title in the name of the trust. Your name as trustee of the revocable living trust would be important to have. I think there are 5 basic essential documents that I would want to make sure that everybody has, 5 of them. One would be a will, that if you have that, you can particularly pass personal property. If you need to have a guardian for kids, that's important. It also can act as, you can build a trust in a will, if that's what you want to do. You can also have the assets that flow through the will pour into a revocable trust outside that becomes irrevocable, right, when you die. A revocable trust, when you die, becomes irrevocable, and assets oftentimes will pour into that. Having a power of attorney for assets is really important. A lot of times people will say, well, I have a living trust, I put all my assets in the name of the living trust, I don't need a power of attorney. And I said, did you put your IRA in the name of the living trust? Well, no, I didn't do that because I can't change title to that in the name. That has to stay in my name. Well, what happens if you became incapacitated? Having a financial power of attorney would allow your spouse to go ahead and draw down assets at a higher rate, would allow them to change the investment vehicle if that was appropriate to do. So it's important to have a power of attorney financially, and you can do them springing or effective immediately. Effective immediately is what it says. I go ahead and I give to my attorney, in fact, the ability to sign contract on my behalf immediately. Springing would say something really that unless I am declared to be incompetent, not competent by 2 licensed physicians of the state of Nevada, California, wherever you live, then the power springs into being, but not before. So power of attorney for assets. 2 other ones, a healthcare power of attorney, particularly important. If I cannot make a healthcare decision for myself, I want to appoint someone else to do that. If you don't go ahead and have a healthcare document, you end up going to the court and having a conservator. Anybody had to do that for a parent? Anybody have to go through a conservatorship? Have a guardian appointed, right, to make healthcare? You did, okay. So if you have a healthcare document, I don't have to have a conservatorship. I'm addressing things about who would make a healthcare decision for me. A lot of times people have talked about, and sometimes it's in the exact same document, a living will. Anybody know what a living will is? People say, right, that's the pull the plug, right? You know, how do I feel about life-sustaining, life-support treatment? And sometimes your healthcare power of attorney and your living will are embodied in the same document. California, for example, has a healthcare form that has both in there, and you should just go ahead and fill it out. But I think sometimes people just think estate planning is, I got my will done. I've done my estate plan, and I wanted to say it should be broader than that to look at having particularly the powers of attorney, healthcare, and living will, okay? All right, on tab 3, as we're going through this, and this starts to get into, and again, you can read this other material. I wanted to kind of have a resource guide for you all when we're done here today, but I mentioned the notion of living trust and that I'd come back in here to do that. Has anybody been the executor for an estate? Anybody done that? Executor for the estate? Okay, number of hands. How about anybody been a trustee? Okay. So one of the differences is when I'm an executor, that's a court-administered process. I'm appointed in the will. The court says, yep, you're going to go ahead and act on behalf of the estate. It's typically for a period of time. 9 months, a year, 2 years. In Prince's case, 20 years, right? You know, it will be long. However, that will go ahead and be. But probate, on the one hand, has the advantage that the court will administer the process. So you always had to be filing forms with the court. It's a matter of public record. Depending upon your state that you live in, it can be expensive. So when I practiced in California, you wanted to avoid probate. Why? Because the attorney, me, could charge my fees based on the gross value of the estate. So you can think of California real estate. If it went through probate, I would be taking a percentage of the gross value of the estate. So it can be expensive depending upon the probate laws of the estate. So people look at having a living trust to avoid probate. That's the main reason. Why do I want a revocable living trust? What is that? I want to go ahead and avoid probate, which means, for those who have been trustees, it can be a matter of private record. If I have fully funded the assets in the living trust, Joan Rivers did this. We didn't hear a whole lot about the disposition because she took title in the name of the living trust, so it can be a matter of private record. Also, when the assets are in the name of the living trust, it avoids probate fees, right? The attorney is not charging a gross value, as in California, what I could do. And then typically it can be a bit faster because it's not a court-administered process. You can do it a bit faster than you can with the court-administered probate process. And it's for those three reasons: privacy, probate fees, and avoiding the time and delay that people look at having a revocable living trust.
Is there any difference in the tax rate or?
No. So the best way I say,
okay.
so when I say living trust, think of it this way. If I own all of my assets in my name, that's like owning it in my right pocket. If I go ahead and I establish the Charlie Douglas Living Trust trustee, I change the name of my accounts to, trustee of the Charlie Douglas Living Revocable Trust, and I put them in my left pocket. I don't need a different social security number. It's still me. It's not going to provide any asset protection. It's not going to go ahead and reduce estate taxes. Living trusts will have two purposes: avoid probate, and then they help with disability. So parents, right? Parents, if they get to that point, I'm just, for us, my parents are now 84, 81. And, if they become disabled and the assets are already in the trust, then who's ever named, let's say it's me as successor trustee, I can step in much easier and act for them and help manage the assets. And again, like the springing power of attorney, disability is really determined by a licensed physician of the state that you're in. So good question there. Let's see. The other thing I think is important about trust that's changed, when I started 30 years ago doing estate planning, and I don't practice law anymore, but when I did it, and I did a lot of it, we would go ahead and distribute assets out. I don't know why things changed, but it might be, kids might get a third at 21, a third at 25, and a third at 30. And some of you would be thinking how your estate plans, so we do that. That has more or less changed. That doesn't make it wrong. But what we're seeing is leaving it in trust far longer for the lifetime of the child, the son or the daughter or the kids. And you'd say, well, why is that? I mean, I trust my kids. Yeah, you trust your kids, but you understand that the world may not be trustworthy. Divorce happens, right? You can get sued. The kids could get sued. So with divorce, asset creditor protection, if you keep it in trust for them, rather than distributing it out, I always say, think of a genie in the bottle. Once the asset is distributed out, once it goes to the children, to the grandchildren, it loses the asset divorce creditor protection. But while it's in trust for them, they have a large degree of asset creditor divorce protection, and at some point, depending upon their age, they can be their own trustee. So if the kids are 15 or 20, yes.
So I thought I heard you say that it didn't provide any protection, but it does. It's just no liability.
It doesn't, a revocable trust will not provide any estate planning protection in terms of reducing assets. But when you die, remember I said a revocable trust becomes irrevocable, so if I've given it to my kids in trust for them, rather than an outright distribution, they can be trustees, and as long as it's in trust for them, there's a large degree of asset creditor divorce protection. Here's an example. My mom and dad die, they leave me assets outright in my name. My wife says to me, honey, we own everything in joint tenancy, don't we? The house, the bank accounts, this and that. Why don't you go ahead and let's put this in joint tenancy? Okay? The concern is when I put that in joint tenancy, I could have transmuted the property. I changed it. When you get an inheritance, it's your sole and separate property. But the moment I put my wife on here in the example as joint tenant, then the concern is, have I made a gift? Do we own that jointly together? Things don't work out 2 years later if I get a divorce. The concern is now my spouse, and it could be husband, wife, it doesn't matter, but the idea is then you can lose potentially half of that asset. Change that scenario. If my parents left it to me in trust and I'm the trustee, well, now I don't have to worry about really the asset and creditor divorce protection because it's in kind of a protected account, okay, to do that. Selection of trustee, really important that most of you probably in this room at some point will have and I'll explain the difference between executors and trustees. Executors are the managers of the probate will process. So probate will process is the executor, that's for a shorter period of time. A trustee can be for a much longer period of time. I just said the kids could be trustee of their own trust for 50 years, right? That can go for a much longer period of time, but they're both managers in different forms. I have mixed feelings on the friends and family plan. So, for those of you that have trusts out there, when I was drafting them, if it's a revocable trust, people would say, well, I'm gonna be the trustee currently of my own revocable trust. You're telling me it's like owning it in another pocket, so I want full control and I'll be trustee. And then the concern is, well, okay, if you pass away, and at least when I was doing estate planning and meeting with husband and wife since the beginning of time when we were doing it, the guy always died first in the meeting. Right? That's how we would just do the meeting is, okay, well, sir, if you passed away, and then we would be talking to the spouse and so forth. So usually the surviving spouse, him or her in this case, would be the successor trustee. And then who would it be? Might it be a son? Might it be a daughter? Might they be co-trustee?